In addition to Raj Panjwani, tonight we are fortunate to be joined by three leading voices for animals in Australia. Firstly, I'm pleased to introduce Emeritus Professor David Weisbrot AM, who has been President of the Australian Law Reform Commission since June 1999. In this capacity, he has chaired many major national inquiries, including covering areas such as pro bono legal services, gene patenting and privacy law. And more recently, some of you may be aware, David Weisbrot edited the Australian Law Reform Commission's journal named Reform, which he tells us was inspired by the work of Voiceless, and the subject, of course, was animal law. And there he is, showing it. That's great, David. Secondly, Dr. Siobhan O'Sullivan, sitting on the far end of the panel, is based at the School of Political Science, Criminology and Sociology at the University of Melbourne. Siobhan is a political scientist who has published and guest lectured exclusively in the areas of animal protection, extensively, but certainly not exclusively, in the areas of animal protection and animal law. I've had the pleasure of knowing Siobhan for a number of years now and have sat on her with the Animal Research Review panel. And rumour has it that after a long journey of her own, she will be receiving her PhD tomorrow afternoon. So congratulations from all of us. And finally, Tara Ward is a senior government lawyer and a graduate of the Sydney University School of Law. In 2006, Tara enrolled in the animal law course here at the University of New South Wales, which was the first of its kind in the country, although I'm very delighted that we now have animal law taught or scheduled to be taught in about 8 schools across Australia. And Tara was clearly such a standout student that she was invited back to teach the course in 2008. And I understand she'll be happy to talk to prospective students after the panel discussion as well. I'm going to begin our panel discussion by asking the panellists to share their thoughts on pressing animal law issues in Australia. One of the issues that Raj Panjwani emphasised, I think, towards the end of his presentation was the constitutional duty of every Indian citizen to have compassion towards living creatures. The Australian Constitution, of course, contains no such provision. In fact, it doesn't even mention animals other than fish. But to get things started, I would like the panellists to assume hypothetically that a referendum has been held, the result of which is that Australians must now treat our fellow creatures with compassion. David Weisbrot, what is the first law that you would pass and why?
Thank you. Well, assuming a successful referendum in Australia is more than just a wish, it's almost science fiction. But let me just take one step back and pay my respect to the traditional owners on whose land we're meeting this evening, and then also pay my respect to the contemporary custodians of this piece of land at University of New South Wales Law School, which I think has shown remarkable leadership in this area, starting with a course it offered several years ago and continuing through to co-sponsorship of this animal lecture series. I'm a former member, proud member of the faculty, but I continue to be proud of the things it does in this area. And also I should say that I'm a relative newcomer to this area, and I guess swept into it by the enthusiasm, compassion, and genuine decency of the Sherman family and Katrina Sharman, who's no relation, but shares the decency and compassion part. And I've really been on an interesting journey as part of that, and I didn't know much about this area until last year when Brian and Katrina asked me if I would be a commentator on Stephen Wise's talk, and I thought, well, I better learn something quickly before I do that, and I immersed myself in Stephen's literature and then got excited and went to Katrina, like a good student, went to Katrina for extra reading and found myself really drawn in and inspired by Stephen's talk that evening and much of the writing that he's done and the practical work, the litigation and teaching and so on that he's done. And I feel similarly about Raj Panjwani's talk tonight, which was fantastic. The images are disturbing, as they always are in this area, but I think we need to see them because it's easy for people like myself to ignore all of that and to go to the supermarket and grab something that's neatly and brightly packaged and forget what's happened along the road to that product being delivered and marketed by professionals. It's also interesting to see, and it's inspiring to hear about the Indian Constitution, which contains a positive obligation on people in that country to show compassion to all living creatures. As Katrina mentioned, our Constitution doesn't have a similar provision. It mentions in passing that the Commonwealth has power to make laws in relation to fisheries, not fish, but fisheries. But our Constitution doesn't have a similar provision in respect to compassion to all living creatures. In fact, it barely mentions people at all. And it contains very little of that kind of directive sentiment. Our Constitution, particularly those of you who've studied constitutional law, know that it reads a lot more like one of those manuals you get with a toaster or a microwave oven. It's very practical. It defines things. It tells you what you switch on and off, except our Constitution probably has a bit less of the poetry and high-minded sentiment of some of those manuals. So we're going to need to provide that ourselves. The laws that Raj showed, which he's been able to take the Constitution and leapfrog on them and have the judiciary give them some meaning, are paralleled in some ways in Australia, but we don't have that underlying sentiment, that bite, that would empower judges to develop them in that kind of sympathetic and sensible and progressive way. So, now to finally answer your question, Katrina. My first law would be a Truth in Animal Welfare Act. So we actually have, every state and territory in Australia has animal welfare legislation or something that's very similar to that. And in New South Wales, for example, we have a Prevention of Cruelty to Animals Act, 1979. And I actually it was a great bit of Freudian research slippage, but I had to ring Katrina earlier this afternoon and saying, I'm on the Austlii website and I cannot find that piece of legislation. And she said, the prevention, I said, I was looking under C for the Cruelty to Animals Act. And I wasn't kidding, I just assumed that was what it said. But we have provisions that read beautifully. Under the Crimes Act, we have an offence, and again, this is fairly typical in Australia, that makes it a crime of serious animal cruelty, where a person, with the intention of inflicting severe pain, tortures, beats, or commits any other serious act of cruelty on an animal, and B, kills or seriously injures or causes prolonged suffering to the animal. Now that's exactly how we would like it to be worded. And in fact, it doesn't carry a 20 rupee penalty, it carries a maximum penalty of up to 5 years in jail. So at this point, we think we've got some good, serious legislation here, until you read, and there always is, a subsection 2. And subsection 2 turns the whole thing around and defines it in exactly the wrong direction and says, however, it's not, someone isn't guilty of this offense that I just read out, they're not criminally responsible, if they acted in accordance with, and I'll quote, routine agricultural or animal husbandry activities, recognize religious practices, the extermination of pest animals, or veterinary practice, or with legal authority under the Animal Research Act. So we have the exception to the general rule being defined by practice rather than saying the practice should be defined by humane understanding, compassion for fellow creatures, and so on. And if you think about it, we would never have allowed a situation to develop where governments 100 years ago abolished slavery and said, we hereby abolish slavery, except if it's done in accordance with the standards of plantations and cane fields and so on. So we must go back to those first principles and say, if what we're about is that subsection 1, then we mustn't let it be overrode by practices that are not always in keeping, they sometimes are, but not always in keeping with the standards we would like. If I could have a second one, or well, actually, it'll be part of this same act, but part 2 of this act would I think, and I wasn't aware of Raj, that Raj was going to say this, but I would also like to see much, much better food labeling laws. We actually have quite a good scheme in Australia of food standards that's jointly administered by Australia and New Zealand, but it deals exclusively with hygiene and food safety, food quality. It doesn't deal with how that product gets to market and the humanity and the compassion that's shown along the way. And I think we must build that into our food labeling laws and then unleash consumer power. And I'm quite confident that most Australians would vote with their pocketbook and do the right thing and drive good behavior that way. Katrina mentioned this edition of Reform that the ALRC did. And again, this is very much inspired by Stephen Wise's talk last year and the reading I did for it and the people I met at this meeting. And I should say this is probably the most successful edition of Reform that the ALRC has put out in 33 years. It's got enormous response and so overwhelming that we couldn't keep up with the hard copy books. And for the first time, we put this on our website for free, even though this is supposed to be a subscription journal. It's on for free without the usual waiting 2 years, so we can try to make some money out of it. So if you're interested in any of these issues, you can find it on our the usual alrc.gov.au website, and on our front page there's a link straight to this edition. So thank you very much.
Thank you, David. This is Thank you, David. I'll just take this opportunity to point out as well that truth in legislation, I think, as you called it, is consistent with Voiceless's mission of lifting the veil of secrecy. We do believe that the law is, in general, sadly used as a shield or is used as a mechanism for obscuring a lot of the cruelty that is happening to animals in this country at the moment, and that would certainly be a very good start in terms of law reform, as of course would truth in labelling laws, which follow naturally from that. And Voiceless has published a report on that. If anyone missed it, it should be out the front at the merchandise table. Now that my shameless plug is over, I'll hand over to Siobhan O'Sullivan to answer the same question. Siobhan, what law would you pass and why?
Okay. Thank you, Katrina. I'd like to start by thanking Voiceless and also the University of New South Wales for hosting this fantastic law series, public lecture series, and also I'd like to thank you for having me here this evening. In response to the question, I'd like to first of all commend the people of India and the lawmakers of India for their vision in incorporating animals into the Constitution, and as has already been noted, it's a far cry from the type of constitution we have. And of course, I'd also like to commend Raj on his fantastic work for animals. Now, if Australia's constitution were amended to include compassion towards living creatures, I think on the one hand it would certainly be cause for celebration, and as has already been noted, Australia has a rapidly expanding, we have rapidly expanding ranks of animal lawyers, and I would expect that clause to be used in very creative ways to protect animals. But at the same time, I would also counsel caution. Now, the reason I say that is that the concept of compassion, although an important principle, it is something, and this was touched on by Raj, it is something that can be difficult to translate into effective statutory interest protection or effective legislation that will work efficiently for animals. Now, let me give you an example, and I'm glad you didn't go with an example from the New South Wales Prevention of Cruelty to Animals Act, because I've got one here. Now, in New South Wales, the primary interest protection instrument available to animals is the New South Wales Prevention of Cruelty to Animals Act. The Act's objectives states that the Act aims to A, prevent cruelty to animals, B, promote the welfare of animals by requiring a person in charge of an animal to 1, provide care for the animal, 2, treat the animal in a humane manner, and 3, ensure the welfare of the animal. Yet despite use of phrases such as promote the welfare and humane treatment, which are concepts that I think you'll agree are not too dissimilar from the idea of having compassion, despite the inclusion of those phrases, as every person in this room is aware, many animals in New South Wales are not in fact treated humanely, nor is their welfare adequately safeguarded. Indeed, not only are many animals living and dying in decidedly inhumane conditions, this all occurs lawfully despite the stated objectives of the New South Wales Prevention of Cruelty to Animals Act. As is well documented and as has already been touched on, and as I'm sure everyone in this room is aware, there's a significant discrepancy between the way the government protects the well-being of different types of animals. So the most glaring contrast is, of course, between the way we protect companion animals such as cats and dogs in comparison to animals such as those raised for agricultural products and also those used in research. So, if I were asked to propose a law that gave practical expression to the concept of compassion for animals, I'd say it would have to have two features. The first is it would have to define compassion in a way that gave the judiciary some practical guidance in relation to measurable minimum standards. Now, in saying that, I'd like to remind the audience that in New South Wales, under the Animal Research Act, there's no minimum standard of interest protection afforded research animals. Under New South Wales law, an animal researcher can do anything, and I mean anything, any kind of harm they wish to an animal used for research, so long as they receive permission from their institution in advance. Now, there's one exception to that, which occurs in the case of toxicology testing. You need 2 layers of approval for toxicology testing, but that's the only exemption. So you can comb the New South Wales Animal Research Act and its accompanying codes, regulations and guidelines, and you will not find a single incontestable minimum standard of protection for animals. Now, when you have to live your life without minimum standards that either protect you against harm or that oblige other people to provide you with the things you need in order to live your life or indeed to thrive, you are very vulnerable. So it might be that you end up living in fantastic conditions, but it may be that you also end up living in atrocious conditions. And when there aren't minimum standards, it's very difficult for the law to protect those who are most vulnerable, for those who find themselves in a really difficult situation. And on this point, I think it's also appropriate to remind the audience that when it comes to the state protecting the interests of humans, we don't accept vague platitudes. We expect detailed minimum standards that specify exactly what we're entitled to. That brings me to my second point. The second thing the law would need is it would need, if the concept of compassion was to be meaningful in legislation, it would have to be applied to all animals equally. Now, if the principle is compassion towards living creatures, then I would say that the most important thing we could do legislatively is to construct statutes that demand that we're equitable in our treatment of animals. It's not enough to be compassionate towards some living creatures. We can all do that. We can all choose to be kind towards some living creatures. But we must be kind towards all living creatures. Now, let me highlight this point with another example from New South Wales. Currently, under New South Wales law, when a dog is transported by a commercial animal transportation service, it's a legal requirement that the dog be provided with, and I quote, sufficient space for the animal to rest, stand, stretch fully and turn around, end quote. Yet despite this requirement, at the very same time in New South Wales, when it comes to transporting hens for commercial purposes, the law allows hens to be transported at a density of 25 birds per square metre. Now that's double the stocking density that you find in a factory farm. It's double the stocking density that you would have seen on the slide earlier. In New South Wales, the transport regulations for dogs strike me as compassionate. The transport regulations for chickens strike me as selfish and callous. So to conclude, in my opinion, the first law that we should pass, the first law that should be passed to give statutory expression to the concept of compassion towards living creatures should be one that sets minimum standards that are measurable and one that also demands consistency in the way we apply those standards to all animals. Thank you.
Thanks, Siobhan. Some really insightful ideas there, and a couple that I wouldn't mind to comment on, but I'm just conscious of the time, and I know that the audience will want to have some question time. So before I have my 2 bits worth, I'll certainly let Tara, I'll pass the baton to Tara to have her say now on what animal law she would pass, given the opportunity.
Thanks, Katrina, and thank you, Voiceless, for running this excellent lecture series and for having me on the panel. I've actually come up from Canberra for Raj's presentation tonight, and it was extremely well worth it, thank you. And as you've probably heard, since this is a story that's actually been reported around the world, there's currently a desperate fight happening in Canberra at the moment to save the lives of about 500 kangaroos who happen to be living in the city in an enclosed area on Department of Defence land. Now, the issue with these kangaroos is that so-called experts have determined that these kangaroos are threatening the survival of a number, probably no more than 5 or 6, endangered lizards that are also thought to live on the same site. And the kangaroos are supposed to be threatening their survival because they're grazing on the native grasslands, as kangaroos do. So these so-called experts have also determined that the most humane way of dealing with this situation is to round up the kangaroos, to dart them with tranquilisers and to lethally inject them. And so far, over the last few days, about 100 have already been killed in this way. So for tonight, I wanted to think of a law that would protect the kangaroos and the lizards, and indeed any creature that can feel pain and that can suffer. And as to what form the law would take, I've recently been thinking about the perhaps contentious idea of rights for animals, and if humans were to give animals rights, what they might consist of. So I thought for tonight I would try to come up with a right that I would enact to protect the basic interests of animals in avoiding pain and suffering, and that could then inform other subsequent laws as they're passed under our new constitutional requirement of treating our fellow creatures with compassion. So the first characteristic of this right would be that it would be very broad. That is, there would be no exemptions, as have already been well discussed, based on the categories that we like to put animals in. If there's a right for animals, it must apply to all animals. So what we'd be trying to avoid here is a situation that Siobhan has already mentioned, where animals that are cute and furry are in, but those who happen to be slimy or who live in water or that breed prolifically or that are kept for human consumption are out. And then I was thinking, not only should this law apply to all animals, but it should also apply to humans, so that with this first law, we would start to overturn the dichotomy that underpins our legal system, and indeed our relationship with the natural world itself, between us humans and all the other animals. In other words, between us and them. We all share certain fundamental interests, such as the interest in avoiding pain and suffering, so the law should protect those interests equally. And the point of expressing the law in the form of a right would be to recognise that all human and non-human animals have certain fundamental interests that cannot be traded away, no matter what the benefit to other individuals may be. So when it came to thinking about exactly how the right would be worded, I've tried to think of one right that would achieve the greatest possible benefit for sentient creatures in one fell swoop, just in case it's the only chance that we get. And as I basically would want all sentient creatures to be protected against the infliction of pain and suffering by human beings, I thought the right could be modelled on one of the very few absolute rights held by humans, which is the right to be free from torture or cruel treatment. In other words, I would take a right that has hitherto only been thought relevant to humans and would apply it to all sentient creatures, human and non-human alike. So my first law, which would be expressed in the form of a right, would simply be that no sentient being may be tortured or treated in a cruel, inhumane or degrading way. And that's it, full stop. The law would contain no qualifications such as unnecessary cruelty, or no subsection 2, as David has mentioned, that exempts all the animals that we want to keep using for various purposes from the effect of the law. And by expressing the law in this way, it focuses on the consequences for the rights holder, i.e. sentient creatures, rather than targeting or banning any specific human activity. In theory, these activities could continue, but only by respecting this fundamental right of all sentient creatures. So to conclude, the aim of my first law, which would be enacted as a fundamental right, would be to give all sentient creatures, whether human or non-human, domesticated or wild, threatened or abundant, greater protection of their interest in avoiding pain and suffering. Thanks, Katrina.
It's back on. Thank you, Tara and David and Siobhan. Clearly we have three animal law visionaries on the panel, and I'd like to commend all of you on those insights. Unfortunately, as most of you know, we're not in a position to amend the Constitution today. In fact, our Constitution is notoriously difficult to amend. I'm sure David could give us the correct number of times that the Constitution has been a referendum. I think it was 9 successful referendums out of 44, but you may have the exact stats on that. It's quite difficult. My point being, of course, that this is a mission that we are going to be on for a while, those of us who are working to change the fundamental interests and improve the lives of animals. But each time that Voices has a function involving lawyers, I note that the numbers are growing, and I can only stress again, this is a movement which is gaining momentum, and I'm certainly hopeful, having heard what we've heard so far tonight, that whilst we may not have a constitutional amendment, we have some fine minds, and we certainly have the tools to work with, and I think that we are going to see some change on the way. This is a social justice movement. So on that note, I note that we have a very short time for questions, but I believe there were some roving mics in the audience. They may have roved out of the room. Oh, great. We have Clay on the left there. If anyone has any questions, I'd like to invite Raj back to the stage as well to field questions. I'm sure, Raj, that your thoughtful presentation has inspired lots of musings from the audience, and they've had some time now to formulate those questions. So if anyone would like to go first, do we have any questions? Yes, down the front here, Clay. Thank you. And if you could just state perhaps who you are addressing your question to, if it's to a particular panel.
Is that right? Is this thing going?
Yeah, I believe that's for Siobhan.
Siobhan, sorry, yeah.
Question for Siobhan.
You mentioned the Prevention of Cruelty to Animals Act in New South Wales. Section 9 of that Act says that any animal which is contained for 24 hours or more must be given the opportunity for exercise. That's broad. Under the Act, there's a code number 5 which sets the minimum standards which apply to all animals, particularly dogs, which are housed in commercial properties, council pounds and others. And the standards, it says, must be complied with. Must be complied with. Section 8 of that code says exercise. A dog must be given the opportunity for exercise, and exercise may be in the way of walking for 10 minutes twice a day or some other way. That is not enforceable at law, and I'm confounded. We have dogs in the Blacktown pound.
Sorry, sir, could I perhaps just, because we're on a time limit, if you could just formulate the question. I think Siobhan's heard the question though, so thank you for your thoughts. I think they're very important, and I'm sure Siobhan has some input on that.
Yeah, look, there are two things to say. The first is that non-enforceable laws are not valuable laws. We need to formulate laws that are workable and that can be enforced, and we need to put resources into enforcing them for them to have a meaning, for them to have an application, and for them to benefit animals. But I might also draw your attention to the fact that under the New South Wales Animal Research Act, there's no requirement that dogs receive exercise. So if you happen to be born a dog that goes off to a lovely home somewhere, then you may well get very good exercise. But if you happen to be a dog that finds his or her way to a research facility, there's actually no requirement at all that you receive exercise. And of course, as you rightly point out, you may well end up being a dog who is legally entitled to exercise, yet it doesn't occur, and who would ever know?
Thank you, Siobhan. And I might add to that as well, because now I have the mic. Just on the point of minimum standards that you made earlier, I certainly would agree that, you know, where possible, we need to enact minimum standards, and animal research is a good example of where that should take place. But just as the law is only a powerful tool if it's enforceable, I would suggests that we need to approach the issue of minimum standards with some caution, and I would remind the audience that we have codes of practice for animal welfare in this country, lists and lists of them, that are really entrenching the horrific conditions in which farm animals are being kept, and that is all being done by minimum standards. So we have minimum standards in which 20 meat chickens can be kept per square metre. We have minimum standards that allow a chicken to have this amount of space in which to move. We have minimum standards that allow not dogs, but certainly farm animals to endure all kinds of mutilations without pain relief. And I know that I'm assuming you would counsel against those kinds of minimum standards, but clearly this is a debate that has to be had.
Yeah. I mean, look, I think we can distinguish between minimal standards and minimum standards. We can set the minimum standards very, as high as we wish.
Thank you. Okay, and are there any other questions from the audience? There's a question down the front from Lee Rhiannon.
Thanks very much. A question to Raj. Firstly, thank you for your speech. It was very inspiring. I was interested in your comments about labelling, and you said how it was achieved by the judiciary. Could you expand on how it was achieved? And particularly I'm interested in how public opinion impacted on the judiciary in terms of achieving that change.
Public opinion is the most crucial and fundamental thing, because even when we talk about judiciary, we have what we call the principle of legitimacy. And without legitimacy, none can exist. So obviously there was public opinion which legitimized or gave the power to the court to come forward and pass such a judgment. Because as he just said, because it's such a law which everybody will agree to. Because all we are asking is, we are not asking them to disclose the ingredients, the formulae. We are not asking anything of the kind. We are trusting you. Please put it just by a symbol. If he has, please put a red one. If it doesn't, put a green one. So, but judiciary not to answer the second one. The judiciary was able to do it because we are looking at the freedom of speech. The freedom of speech has got its counterpart. That is the freedom to receive information. The freedom to receive information gives you the power to evaluate and create ideas and to nurture opinions, which I mentioned about it. So you must give me the information because that is my right. You cannot deny me the information. And that information is for what purpose? To discharge my duty towards compensation, towards towards compassion.
Thank you, Raj. I'm mindful of the time. I think we may have time for one more question. And did I see the Dean with a question there before? Or I can think of no better person to ask the last question for the evening than the Dean of the Law School, David Dixon.
Question or partly a comment. I mean, the idea about using law to prevent cruelty to animals there's a temptation to think of law in simplistic, symbolic ways, that you have to pass legislation, you have to amend the Constitution, you have to do this. The reality of the way in which law is actually used to control activities in modern society is that law is used in a whole variety of ways as a regulatory method, and a lot of that regulation is devolved to other bodies to carry out the controls which are necessary. So to use the example of talking about what happens at a university like this, which does a good deal of scientific research, the idea which was implicit, I think, in the way in which it was talked about before, was that animal research is somehow unregulated because there aren't specific standards set into national legislation is completely misleading. The kind of regulation which is provided is through animal research ethics committees, which provide extremely strict control over the way in which animals are treated in the research facilities of this university. And in fact, to suggest that what you need to do is simply have broad national legislation, ignoring the realities of the kind of genuine regulation which already exists at devolved levels, is I think, actually doing a disservice to the objective of protecting animals from cruelty.
Thank you for those thoughts, David. And the issue of animal research is clearly a vexed area, and certainly one of which there has been quite an amount on both sides of the debate, if I could put it that way, that has been written. I know that Siobhan has written extensively on the area of animal research law, as have I, and we'd be happy to make those publications available, and also to hear the views of others, or to see them published in the upcoming Australian Animal Protection Law Journal, which John Mancy, who's sitting in the audience, will shortly be pioneering this year. So certainly some interesting ideas there, and I think this is a discussion that we'll have more to say about. And on that note, I might wrap up for the evening because I see we've gone over time. I wanted to take this opportunity again to thank Raj Panjwani. I reiterate, I only wish we had more time to hear your insights. I feel like we only...
for taking away their time. I'm so sorry about it.
And I'm sure that Raj will be getting a lot of media in the next few days, so you can continue to explore his views through that mechanism. I'd also like to take this opportunity to thank the panellists, especially Siobhan, who's come from Melbourne to be here tonight, and Tara, who came from Canberra. Professor David Weisbrot, you continue to inspire us with your leadership in this area. And we do hope to have your continuing contribution in this area as this movement gains momentum. And finally, or almost finally, thank you to the Voiceless team for all the effort that you've put in this evening. This is a mammoth event. This is one of only a number of events that are on the calendar for the lecture series over the next couple of weeks. Special thanks to my colleague Sarah, who is my wonderful attribute, rather a wonderful asset to the Voiceless team, and to UNSW for allowing us to have this series here, to Christine Brooks and Hilary Blackman for their effort in making tonight possible, Brian Sherman, of course, for his leadership. And thank you very much to the audience for coming tonight and for your patience and for your contribution. There will be drinks and refreshments upstairs if you'd like to stay and continue the discussion, which I think is only beginning. And thank you again to the Voiceless volunteers, some of whom are alumni who've come back for tonight to help us out. Thank you again.